Good afternoon, and welcome to the Deason Center's revamped student programming series we're calling Deason Discussions. This afternoon's presentation is co-hosted with SMU Law's Criminal Law Society and features attorney Matt Kita discussing excessive force and qualified immunity. Thank you to Briante Boss and Patrick McGuire for reaching out to the center about this programming. For those of you who have not yet met me, my name is Kenitra Brown, and I am the staff attorney and engagement coordinator at the Deason Criminal Justice Reform Center, housed at SMU Dedman School of Law. The Deason Center was established in the law school in July 2017 under the direction of Professor Pamela Metzger. The center brings a stats and stories approach to criminal justice reform. We use stats to emphasize the stories of real lived experiences of justice-involved people to make compelling cases for criminal justice reform. We tell these stories through research, education, and advocacy. While our primary areas of research concern prosecutorial discretion, public defense, and small tribal and rural criminal justice, our engagement agenda recognizes that we don't and can't do our work in a vacuum. And so it includes conversations about salient criminal justice issues in the national and/or public discourse. Given the current climate, we want our Deason Discussion Series to not only engage law students as future attorneys in these important discussions, but to include other students and other interested members of the university community. Lawyers are change makers, but everyone has a role to play in learning about these topics and applying these lessons to their daily work and discourse. Now, I'd like to formally introduce Attorney Matthew Kita. Matt Kita is a solo appellate practitioner with his home office in Dallas, Texas. Originally from Buffalo, New York, Matt graduated from Boston College with a bachelor's degree in political science, from the University of Maryland with a master's degree in education policy, and received his JD from the University of Houston Law Center. After law school, he served as a law clerk to Justice Eva Guzman of the Texas's 14th Court of Appeals. Since May 2012, Matt's practice has focused primarily on authoring briefs and presenting oral argument in Texas's state and federal appellate courts. His civil practice is concentrated on representing victims of personal injuries, civil rights violations, and reputational torts. He has argued and obtained favorable results for his clients in the Fifth Circuit, the Texas Supreme Court, the Texas Court of Criminal Appeals, and several of Texas's intermediate appellate courts. He passed the California bar exam in 2017 and has expanded his appellate practice there as well. In 2012, Matt received the Dallas Trial Lawyers Association John Howey Award, which is given for the courageous pursuit of justice in the face of adversity. Since 2014, he has been selected as a Texas Super Lawyer and as D Magazine's Best Lawyers in Dallas. Matt is a proud member of the Board of Directors for the Texas Trial Lawyers Association and serves as a chair of its amicus committee. He is also on the Board of Directors of the Texas Trial Lawyers Association and is a long-suffering fan of the Buffalo Bills. I'd like to remind everyone that we are recording this presentation. If you have questions, please hold them until Mr. Kita finishes his presentation or type them into the chat, and time permitting, Mr. Kita will address them after the presentation. Please also make sure you keep yourselves muted through the presentation. Please listen to learn, be respectful and thoughtful, and be mindful of your comments since this is technically a public forum. Please welcome Matt Kita.
Thank you very much for the kind introduction. You asked me to send some stuff about my bio, but I never anticipated that you would read the entire thing. So frankly, being a Buffalo Bills fan is very helpful to prosecuting civil rights cases. As you'll come to find out, these are, unless you've been living under a rock for the past year or so, becoming more and more frequent, more and more discussed in the news, and the issues relating to why they are so difficult to win is really being questioned both in the courts and in the halls of Congress. Noted, this is obviously being hosted by the Criminal Justice Reform Center. I'm guessing that many of you have criminal justice reform as an issue that you would like to pursue or would like to contribute to. These cases, taking civil cases against public servants, are very hard, but they're very, very important. I like to say that they're the cases that you went to law school for. They're the ones where you can make the most difference for the most marginalized people in our society. And, I'll get to this later, but you think about it when you hear about police using excessive force, it's rarely because the police broke into a Highland Park mansion and rammed down the door and had the wrong address and something like that, and it was an upstanding orthopedic surgeon in the neighborhood. What they usually are cases where people that are involved in criminal activity are being apprehended. The only witnesses are other people with other criminal records, and you're fighting the force that is supposed to keep us safe. And I think there's a lot of pushback towards people that do what the kind of work that my colleagues and I do, because it suggests that you're against the men and women in blue, excuse me. And that's simply not the case. No one likes bad cops, especially good cops. And what the Civil Rights Act was designed to do was to keep people from engaging, giving a financial disincentive to municipalities for hiring people that aren't up to the job, and to give a financial disincentive to officers from abusing people's civil rights. Now, I have a PowerPoint presentation, which I'll sort of walk through, and I really don't like just sort of saying everything that's on the slide, but a little bit of history matters. And what I'm going to try and do is sort of walk through how we got the ability to file these cases in the first place, and then offer 10 pieces of advice for should you take one of these, or should you decide to spend your summer internship or associateship working for a lawyer that does this kind of work, things that you need to watch out for. So to get started, the Civil Rights Act of 1871 was originally called the Ku Klux Klan Act. And essentially there were a lot of rogue officials throughout the South that would deputize individuals and have them commit horrific acts against African Americans specifically, but other minorities, Catholics, Jews, etc. Everything from harassing them to keep them from voting, random lynchings, things of that nature. And when Congress realized that its Reconstruction efforts were being thwarted by rogue state agents that weren't particularly happy about the outcome of the Civil War, it passed this statute, which has remained virtually unchanged in, I'm a lawyer, so I can't do math, but like 149 years. So the important thing to note here is that this is the statute. This is the source of the ability to bring a lawsuit. But note some of the words that are used here. It's a person, actor under color of any statute of any state. And it says person. It doesn't say anything about the federal government. It doesn't say anything about municipalities or counties or anything like that. It says a person acting under color of law of a state. And so over the course of the past 100 or so years, it's been up to the Supreme Court to expand on the statute when Congress wouldn't. So maybe you remember this from your con law class, but in 71, the Supreme Court decided Bivens versus 6 unknown named agents, where they said person, they essentially allowed federal agents to be liable as well. It shouldn't make a difference if the FBI commits an excessive force violation versus a Texas Ranger. Excessive force is excessive force. In 1978, the Supreme Court decided Monell versus New York, in which they said that a municipality could be a person within the meaning of Section 1983. And this is obviously very important, because suing a police officer that might make $70,000 a year is not likely to really bring the client the redress that they're looking for. What you're really looking for is the municipal treasury, and the policy change you're trying to influence is for them to stop hiring people that abridge the constitutional rights of the people that they're paid to serve. In Canton, Ohio versus Harris, the court expanded it even further and said that not only can you have a suit against a municipality when there is an unconstitutional customer policy, but you can also sue them when there's a failure to train, there's a deliberate indifference to the toleration of unconstitutional conduct, even if it's not formally written down. And many of you may know this or have read about it in cases, but the Dallas County District Attorney's Manual literally used to have a provision in it that said, do not put Negroes, Dagos, Jews, women on juries because they're inclined to acquit. Okay, that was a specific unconstitutional policy. Fortunately, the governments have wised up a little bit, and they really don't do that anymore. But there's lots of times, as we all know, where they turn a blind eye towards things that are patently excessive or unconstitutional. The problem, however, came in 1982, and it was sort of percolating for years, but a case called Harlow versus Fitzgerald, and if you're paying attention to these issues, you've probably seen it in the news. In Harlow versus Fitzgerald, the court tried to engage in some legislative balancing, if you will, or policy balancing, I guess, where they were saying, you know, we can't have all of our policemen or all of our public servants, any state actor, whether they're a teacher or a mayor, whatever, in courtrooms giving depositions all the time or constantly on trial. So they tried to set up this balancing test that would allow suits to be brought if they were meritorious, but basically created an affirmative defense that the plaintiff had the burden to rebut from the outset to show that the actions complained of were objectively unreasonable and that they violated clearly established law, and that no discovery should be allowed until this threshold test is satisfied. The problem with this is that since from 1982 to the present, the clearly established law prong of this test has been the focus. The court has said you can address these in any order. And so what the courts have been doing is looking to see if you can find a case that's virtually exactly identical to the circumstances that your client suffered. And then if you can't, from your binding jurisdiction or from the Supreme Court, they'll say the law wasn't clearly established. So even though he committed a violation, he's entitled to qualified immunity, and therefore he or she is dismissed from the suit. Now that obviously doesn't make a lot of sense. And even justices like, well, now Judge Don Willett, who used to be on the Texas Supreme Court, now is on the Fifth Circuit, hardly known as a radical liberal, he's penned numerous dissents saying this is essentially turning it into unqualified impunity. As long as you're the first person to do something badly, then you get the free pass. But if that's law, then nobody has any incentive to bring the case in the first place, because they know if they're the first one that had that circumstances, they're going to lose. So what incentive does a lawyer have to undertake all of that cost, or the plaintiff have to undertake all of that emotional damage just to get something in the Federal Reporter? So what I'm trying to do here, finally, this case you probably learned in your first year of civil procedure class, but Ashcroft versus Iqbal do not allow conclusory statements. And this is really hard for civil rights cases because you generally don't know very much about what happened, and you're not entitled to discovery about it until after you satisfy the test. So you're sort of in a Hobson's choice where you have to plead the case in order to get it into court, but you're a large time just guessing as to what happened. So a conclusory statement would be, Officer Smith violated my Fourth Amendment rights. Respectfully submitted, Matt Keita. That's not going to fly. You're going to have to explain not only exactly what happened, but why there's a factual dispute that the court needs to resolve. Because remember, qualified immunity is decided on summary judgment. So these are all the procedural hurdles that the Supreme Court has given us over the past 30 odd years to make these cases harder and harder to bring. They're not, however, impossible. And I've had some success at the Fifth Circuit, which I think is, without question, the most conservative federal appellate court in the country, getting them to weaken the standard under Harlow versus Fitzgerald over the very, very, very angry dissents of about 6 or 7 recent appointees. But of the 17 justices that are on that court, I have about 9 of them that have gone with me, which is, a good thing, considering the majority will win. But anyway, so starting in on my 10 points, or 10 things to just remember about these cases. The first is that you're not going to find anything in the US Code discussing the statute of limitations. The statute of limitations for a 1983 case is based on whatever the statute of limitations is for a personal injury tort case in the state where you're filing suit. So for obvious reasons, that's a good thing to know. The second thing is that you can file these cases in state court, but you will almost certainly be removed to federal court in every single one. The only exception I can think of is some states, California in particular, have much more liberal civil rights laws that are part of their state code. And you might file simply just a state cause of action and not a federal one, in which case there'd be no basis for removal. But if you're not familiar with federal court practice, or you're not, you haven't done that before, you need to find someone who is, because federal courts not only were backlogged, especially say you're filing in the Northern District of Texas, we were down 4 trial judges for nearly 4 years, actually longer, nearly 6 years, because Congress wouldn't approve any of Obama's nominees, and it just took forever for Trump to get, caught up to date. So these judges have, 900 cases apiece on their docket, plus a criminal docket that's ever expanded. If you don't do it right, if you don't plead the case right from the outset, you are going to spend a year in pretrial motion practice, where the other side's going to file a 12b6, and you're going to have to respond. They're going to have to reply. You have to wait for an opinion, and it's just not worth it. Do it right the first time. And if you're not familiar, again, if you're not familiar with federal practice, find somebody who is. The key thing is that the courts have now held that if you don't plead sufficient facts to defeat qualified immunity in your original petition, the case is subject to dismissal. So before you go off and file suit, doing as much investigation as possible is absolutely key, because what you want to be able to do is plead facts that show that there's a dispute as to what actually happened and what the government knew. And one of the cases that I was lucky enough to be on the winning side of was a case called Darden versus City of Fort Worth. And in that particular case, a SWAT team stormed into a suspected drug house in a lower income neighborhood in Fort Worth. And on the couch was this really, he's 5'7", 350-pound man. And as soon as the officers came in, he put his hands up in the air, and some of them were wearing body cameras on their helmets, but they ran right past him. They were running into the bedrooms looking for drugs, and nobody really saw, none of the cops anyway, could say what actually happened. All of his cop friends that were in the house with him insisted and testified and offered affidavits that they repeatedly told the officers, he can't breathe, he has asthma, he's having a heart attack, etc. And the officers ignored all them and tased him to death. And the other side, the city and the officers filed a motion for summary judgment on qualified immunity, saying that this was just objectively reasonable. When you exercise a no-knock warrant, you have to expect that you're going to have some resistance to the people inside. And I argued that no, if he was complying with their statements but was having a heart attack, that's a fact issue. And the jury's going to have to decide whether they're going to believe the cops or believe the other people in the house. And we won that case. Ended up losing at trial, unfortunately. But we made good law in the process, because the Fifth Circuit actually said that the eggshell skull rule applies in these 1983 cases, and that the officers are going to take their victims as they find them. And that's very, very important. Again, I just covered this a second ago, but you have to plead the lack of qualified immunity. And this is probably something you didn't go over in civil procedure, because it literally never happens. But there's a rarely used rule, Rule 7A, and it authorizes a district court to order the plaintiff to file a reply to an answer if it feels that not enough information is in there. It's kind of obscure, but the city will ask for it, or the municipality will ask for it in every single case. Why? Because they're not billing a client by the hour, and they can, time is always on their side. So they file a motion for the 7A reply, and the judge takes a while to write an opinion on it, and then you have to file one, and then they say it's insufficient, and pretty soon a year and a half has gone by, and you're not any further along than where you started. In the meantime, memories are starting to fade. So that's why I'm saying that if you could plead as many facts as possible to get yourself around a qualified immunity defense, just assuming that all your facts are true, you're going to avoid a year and a half of federal motion practice, and might even be able to put yourself in a position to seek a motion for sanctions, something I never do, just because I just don't like doing that. But obviously, if you have clearly articulated a fact issue and they're saying you haven't, there's at least a good faith basis for saying that they're not acting in good faith. The clearly established law prong is important too, even though usually you don't have to recite case law in an original petition or a complaint if it's in federal court. You're going to have to research cases from your circuit and from the Supreme Court and devote a substantial section of your pleading to why you believe that the cases that are decided are similar enough to your circumstances that the cops should have known better. This whole notion of clearly established law is so absurd that it's hard for me to be neutral about it. The idea that Dallas police officers are getting off their shift and then just going down and getting the latest volume of the Federal Reporter and perusing through the cases to see what's happened is obviously nonsense. You know, they go through the same training program that everybody else does in the state that's mandated. They take the same courses that are mandated. They get the same updates as everybody else, you know, but this idea that you have to find something that's on all fours is really stupid. And this is the part that we're trying to change. I had 2 cases that were pending in the Supreme Court last year. There were 10 total, and this is the US Supreme Court, and they denied all of them. And I think there's one that's still pending, but it wasn't fully briefed yet, so they hadn't dismissed it yet. But all of them were saying this clearly established law part has to go. It's just simply unfair. And I think in one of my briefs, I quoted a case that the Supreme Court had authored back in like 1987 or something, and they said they're trying to mitigate the damage caused by this requirement. And the Supreme Court said, well, just because there's never been a case of child welfare officials selling children into slavery, that doesn't mean that, you know, we wouldn't be able to go forward and give that person qualified immunity. And, you know, I responded, well, that's all well and good, but, you know, child welfare officials never sell children into slavery, but police officers, you know, injure and kill unarmed suspects all the time. So like, let's get with the program here. They didn't listen to me. Hopefully soon. There's another part, and that is for any of you that are interested in appellate law, and I'll have my contact information at the end. Would be glad to talk with you because I think it's a really interesting and noble calling, especially to help out trial lawyers that simply don't have the time to do the research and briefing and the legal argument while they're preparing for their jury argument and other evidentiary issues. One of the basic principles of appellate law is that you can't complain about something on appeal that you didn't present to the trial judge below. So what I have is a paragraph that I usually stick in a footnote in every filing that I make, whether it's the original complaint or a response to a summary judgment motion, saying there is no such thing as qualified immunity. It's not in the statute. And there's a whole string of justices of the Supreme Court and of judges around the country that have raised this concern. And it will likely be denied because Harlow versus Fitzgerald is still the law, but you raise it in the trial court and you raise it in the Fifth Circuit. And then maybe your case is going to be the lucky one that makes it all the way to the US Supreme Court. And then you can raise it as a point of issue. But if you don't make it, if you don't challenge QI from the very beginning, you're going to be SOL. And I'm not referring to the statute of limitations. Municipal claims are hard because you can't get discovery on them until you defeat qualified immunity. That's frustrating because, like I said, most municipalities don't have unconstitutional customs written down, okay? They just sort of exist, but you're not allowed to go and depose the chief of police and the other officers on what they usually did. The only discovery you're gonna be allowed to get is on what happened at the day of the incident. And that doesn't tell you very much about your municipal claim. And because the QI claims take so long, if you don't plead it from the outset, you're going to be barred by limitations by the time you actually get around. So the way that I've been doing these with the trial counsel that I'm working with is we do a lot of research on similar incidents in newspapers and on the news, TV news, whatever, you know, for a 15-year period. And you can get that through Westlaw. You know, if you have the advanced subscription, you students probably all have it because you have like the super package, you know, but finding other instances in which the city of Dallas or the city of Fort Worth or whatever tolerated certain incidents that were similar to yours, you know, and that the officer was not disciplined or the officer was not criminally convicted or whatever, and allege those in your complaint, because you're going to need to create a fact issue to show that otherwise they're just going to file a motion for 12b6 at the beginning saying you've just made conclusory assertions of the existence of a policy. You haven't told us about this policy and you have no evidence that it exists. And it's like, again, you're damned and you do if you're damned if you don't. If you don't allege the claim, you're going to lose it on limitations. If you do allege it, they're going to move to dismiss it because you don't have enough information, which you can't get. So that's where you're at. This is another thing that's really absurd, and one thing that I'm fighting very hard in the Fifth Circuit. The city of Dallas has taken the position that its chief policymaker, and that's one of the things you have to identify in your pleading, is who the final policymaker is. Its final policymaker is the city council, which is, again, absurd. The final policy for the police department is obviously the chief of police. The city council doesn't, that's why they hire a chief of police, is because the city council doesn't know anything about policing. They follow their general orders and ask for updates, but they're not, making decisions. Well, the city council is a legislative body, and the city of Dallas takes the position that a legislative body only speaks through the positive ordinances or legislation that it creates, or that it enacts. And that's the only way it speaks. So when you try and take a deposition of a city council member and say, hey, what did you guys talk about after, so-and-so was shot in South Dallas? What did you learn from the chief of police? How long have you, they will claim legislative immunity and say that all of those discussions are absolutely privileged. So they get both sides of the coin currently under the way the Northern District of Texas is ruled. And I'm working in 2 different cases to try and get this flipped, because it's puts us in an impossible situation. They can't say that we're the policymaker, but you can't know anything about the way we make policy. That's just garbage. The failure to trade claims, which I talked about from the city of Canton, Ohio versus Harris, these are the most difficult cases to prove. Again, because not only do you have to get by qualified immunity, but you have to have evidence of other similar incidents, again, without discovery. And in the past 25 years, the Fifth Circuit has only, I can't remember if they reversed a summary judgment or affirmed a jury trial, but went on the plaintiff's side, let's put it that way, one time in 25 years. And it was a case in Bryan County, Oklahoma, I think it was, where the deputy basically, the sheriff just deputized a whole bunch of people that had no training whatsoever, gave them all guns, and told them to go chase some bad guys. And surprise, surprise, a firefight broke out. And they said, all right, well, there was absolutely no training. The problem is that in order to be a licensed police officer, you've had to go to a police academy and pass the tests and gone through the state mandated training. So in every single case, you'll say, well, how in the world did these officers execute a no-knock search warrant and tase someone when everyone around him was saying he can't breathe and he's having a heart attack, and your training specifically says you need to take special care of obese people? And they'll say, well, it wasn't a failure to train. I might not have exercised my training properly, but I went to all these classes. Look, here's my report card. And so far that's sufficed as evidence. Indemnification, especially in the crazy state of Texas, is the biggest problem. In most states, which is usually how I start talking about things when I have to talk about Texas, the city will indemnify an officer if he's convicted, or if he's, found liable for a constitutional violation. Texas law prohibits that. So essentially in Texas, if you get a 1983 judgment against an officer after defeating qualified immunity and all of the interlocutory appeals that they pull and everything else, as soon as the jury signs the verdict and the judge enters the judgment, it's not worth the paper it's printed on, because the city's not going to pay it. So a lot of times what you're really doing is trying to present the most persuasive case possible so that the city will settle it out before you even have to go to trial. Now, some police unions do have insurance policies that will cover this stuff. And in the bigger cities, those exist. So in Dallas, we have a little bit more leverage than in other places. But I had a case in the city of Bel Air, down near Houston, where essentially once the judge determined that the claims against the municipality were inadequate, we had an officer who had shot somebody who was going to be a future Major League Baseball player in the leg when he wasn't looking at him. And he's essentially judgment proof. I think he might have paid $5,000 and just testified, all I have is my house and my cars and stuff that is exempt. And, why bother going through this trial? Why do this to me? So finding out in advance whether or not there's somebody that's going to foot the bill is obviously important. I mean, we all like to do these cases, and trust me, getting your name in the paper is kind of neat the first time it happens, but when you make a career of getting your name in the paper and not getting any money for it, and you're not getting your client any money for it, that thrill goes away pretty quickly. The other thing that's important here is that the claims against the officers always go first. So even though Monell exists, the Supreme Court has held that even if a municipality has an unconstitutional policy, if the officer didn't do anything wrong, it doesn't make a difference if the policy is unconstitutional. So a lot of times the judges will bifurcate the trials, and you're forced to have a jury sit there knowing full well that they'll be deliberating twice. And if they want to get the hell out of there, all they have to do is find against the officer, so they don't have to come back the next day to hear the claims against the city. And like I said, that's a procedural hurdle. That's a real pain in the butt. Of course, the Supreme Court has also held that the officers have an immediate right to an interlocutory appeal on any qualified immunity decision. So you can expect that if you're lucky enough to win your 12b6 motion, it's going to be appealed to the Fifth Circuit, who will then file a writ of cert at the Supreme Court. And if you win there, they'll go back and file a motion for summary judgment on qualified immunity, which if they win, they will take an interlocutory appeal, etc. These cases take a long time. They're hard. They're very difficult, but they need to be brought. And just adding to all of those procedural hurdles that I was telling you about, you consider one of the things that I'm working on with the American Association of Justice is to try and make these cases non-removable. Those of you that have taken any maritime law classes will know this, but if you file a Jones Act case in state court, even though there's jurisdiction under federal maritime law, they can't be removed because we treat merchant seamen with such respect that we wouldn't want them to have a jury pool that's far away from the port. Yet when we tried the Darden case in Fort Worth, we didn't have a single juror from our veneer panel that was selected for the jury that was from the city of Fort Worth. They're from all over Western, Northwest Texas, asked to drive hours into the city to hear complaints about a police department that they have no connection to. Trying to suggest that a police officer is not telling the truth is a lot harder than you think. It might be easy in Compton, okay? In Palo Pinto County, it's not. The officers are deemed reliable, and like I said earlier, excessive force usually occurs on people who are already engaged in criminal activity, and they're not particularly sympathetic. In your federal courts, you require unanimous verdicts. But the reason that we continue to bring these cases is because the only way to change the law is to make the arguments. And I've tried, and I sit there during trial. I don't try cases. I only come out and talk when the jury's in the box and we have to argue about evidence or do the motion practice. But I've been part of 5 different trials, all of which have lost, and all of which have gone up on appeal. And in the appeal, even though it didn't sometimes deem reversed, we're chipping away at Harlow versus Fitzgerald, chipping away at Canton, and chipping away at Ashcroft versus Iqbal, to the point that these cases aren't. If Congress is going to do nothing, which they've shown that they won't, at least right now, qualified immunity reform is I think they said it was a non-starter, was the Trump representative's comment. If Congress is going to do nothing, then the only way to do it is to make good, strong, persuasive arguments to our federal judiciary. And it means maybe partnering up with another lawyer. I'm not trying to promote myself here. There's lots of lawyers in town that do this kind of stuff. There are organizations called the National Police Accountability Project. If you join the American Association for Justice, they have a civil rights and police misconduct group. This is federal law, so it applies, throughout the country. Hundreds of emails a day, new trial strategies, new cases, new developments, new way of arguing these issues that have really hamstrung us over the past decade or two now. And the hardest thing, of course, is losing hurts way worse than winning feels good, and you take some lumps when you do these. But if you can find a way to incorporate these into your practice, to take them pro bono, and to associate with lawyers that really know what they're doing, you can find a way to really affect some change in the world. And that's one of the reasons I hope that you went to law school in the first place. So that's my contact information. Please feel free and give a call or shoot an email anytime. I'd be glad to share this presentation with you if you'd like to see it again, or talk more about these cases. For those of you that are looking for internships or want a little extra work to do on the side, I'm a solo practitioner. I don't have a research staff. I have a woman that helps me out and answers my phones from time to time. But other than that, I'm the chief cook and bottle washer at the Matt Keita law firm here. So if these are issues that interest you and you want to help me with research, try your hand at writing, take a look at the kinds of things that have been done, I'd be more than grateful for the help. And not only would I, but so would all of my colleagues that are doing the same thing. So I'll stop talking and take a look at the comments and stop sharing my screen here for a minute. But let me see if there's anything in the chat. Not at the moment. If any of you have questions for me, feel free and I guess unmute yourself or ask away. If not, you can get back to class or whatever else you got going on.
Hi, Mr. Keita. Thank you again for speaking today. I felt your presentation was very enlightful for all of us. I think something you mentioned was talking about how the test usually talks about what is objectively unreasonable based on prior case law. And I think with seeing these type of cases, we see in the media how they try to talk about, I guess, the officer's subjective intent or maybe even prior racist incidents that officers might have. So can you guys kind of speak to that and maybe sort of dispel that notion that any officer incidents with racism or any subjective intent, if it even comes into this analysis when you're trying these cases?
Okay, so when the court looks at the objectively reasonable prong of the QI analysis, the question that they're trying to answer is, and this is done as a matter of law, decided by the judge, okay? Would any reasonable officer have behaved this way? And sorry for my tangent. One of the problems with this is that we're entitled to a jury of our peers here, and you would think that the question of whether something was objectively reasonable should be objectively decided by the people that are paying the bill. But it's not. Instead, you get, Judge Smales up there or whatever, and he, say, that sounds pretty reasonable to me. QI granted, and that's just how it goes. That's why I focus so much on pleading facts about what actually happened, because that's the only way you can get around the summary. If you want to ask the judge whether he thinks it's reasonable or unreasonable, go ahead. You know what I mean? But that's putting all your apples in one basket. If you can show that there's a debate over what actually happened, the judge isn't able to make a ruling on whether it was reasonable or unreasonable because we don't know what happened. And that's what we've discovered from my Darden case is the way to get around that. Because otherwise, you just you get a bad judicial drawing and a cop-friendly judge. And remember, most of these federal judges spend 90% of their time doing criminal arraignments, and are very friendly with the police. So they see a lot of bad guys in and out of their courtroom. You have to create the fact issues because it doesn't make a difference on the objectively unreasonable part, what this guy's history was in the past, whether he made racist comments, whether he was, failed out of the police academy 3 times. That doesn't make a difference. They will literally look at what was happening the instant that this happened. When those officers in Fort Worth tased my guy, was it reasonable then? And this person could have been a card-carrying member of the Ku Klux Klan, but if any reasonable officer would have said, yes, deploying a taser at that point in time was necessary in light of the fact that they were executing a no-knock warrant, you're going to lose your case. And until Harlow versus Fitzgerald gets modified or Section 1983 gets modified, that's going to be the law. And that's why doing your homework in advance is so important on these cases. I just saw a comment, Kevin, have there been any efforts made to move liability suits against PBA rather than municipalities in order to dodge the problems inherent with seeking judgments against government entities? I have not heard of that. The bills that I was working with AAJ to get filed in Congress were attempting to write out Monell and impose vicarious liability directly on the agencies. I don't know how. I mean, the PBAs are not governmental entities. They're essentially, private trade organizations, if I'm not mistaken, and correct me if I'm wrong. But I don't know how a federal statute would be able to impose vicarious liability on a union for failure to train if it's the police department's job for doing the training. Does that make sense? I mean, again, it's an open question and probably a good idea. And I'll shoot it up the ladder because we're taking any ideas that come and trying to create a law that dissuades, provides a financial disincentive for the conduct that we've been seeing lately.
Can I follow up on Bree's question? When you were explaining kind of the objective, reasonable perspective, is that just any objective, reasonable person? I don't remember what the slide said, or is it based on the role that person is in? How specific, I guess, does the judge look for there? And then how easy is it for you to find evidence sufficient to support your side enough to say that there's doubt on the reason?
So this is the deal. The test in the common law is, would any reasonable officer have done this? Or alternatively, can the plaintiff show that no reasonable officer would have acted this way? Now, like what I said before about how you try and find fact issues about what happened in the first place to beat summary judgment, when you go to the jury and you use the Fifth Circuit pattern jury charge, okay, it will give all of these definitions, okay? Federal court jury charges look much different than state court. They have lots of instructions and paragraphs of information, especially on these types of cases. So they'll say all that, and then the question will be, is Officer Smith entitled to qualified immunity, yes or no? So the key thing, and I hope I'm answering your question, the key thing is just getting to the jury, because the judge is allowed to rule as a matter of law, but thanks to the Darden case, if there's a fact issue, he can't make the ruling because there's a factual dispute that the jury has to resolve. So but if you read the case law, it'll say, would no reasonable officer have acted in the same way? And that's, it's not just a reasonable person. And actually, this is, if you'll allow me to just like complain for 2 seconds, because these cases are so insane that, this is the one that we took to the Supreme Court last year. We had a case in Kaufman County where there were reports that a man was walking through the neighborhood wearing a brown shirt, carrying a gun, and yelling that he was going to shoot himself and everybody else. And police officers and Texas Rangers and DPS officials and sheriff's deputies were all dispatched to the scene. And they all mounted up hundreds of yards away, just to look for this guy. And along comes a kid wearing a blue jacket, riding a bicycle with nothing in his hands. He's 100 to 500 yards away from the officer. One of the officers yells, "Drop your gun." He doesn't. So then 8 of them open fire on him and kill him. Now, we lost the case on qualified immunity at the trial court level because the district judge thought that that was reasonable under the circumstances for the officers to do that because, they were responding to a scene and that person wasn't complying with their commands. And of course, if a police officer tells you to do something, you just have to do it, whatever. Anyway, so I appealed it to the Fifth Circuit, and the Fifth Circuit held, no, this is plainly unconstitutional, and there's plainly fact issues as to whether he had anything in his hands, as to whether he was close enough, as to whether they could see. The opinion from the Fifth Circuit was scathing. And then they said, but there's never been a case like this before, so qualified immunity is granted. So, it's navigating a bear trap, But the argument that I raised, in fact, just give me 2 seconds. I think I have it right here. I think my argument was, hold on 1 second here. I'll find it later. The long story short is, essentially, the judge is saying that no reasonable officer could disagree okay, about whether or not this was appropriate. However, it was okay to let the claims against the city go forward, because reasonable jurors could disagree about whether there should be liability. So in other words, the officers are presumed to know less about the law. Law enforcement officers are presumed to know less about the law than the jurors on the jury that are going to be adjudicating the claims against them. It's beyond nonsensical, and it merits reform. But it only will get reformed if people will come up and take the chance and work these cases. And like I said, you know, fortunately, I have other work to do that can pay the bills. You know, but at the same time, these are the ones that I think are the ones that are my favorite to work on, because you really, you know, I mean, it can make arguments over whether the light was red or the light was green all day long. But, you know, when you have, you know, kid in a shooting gallery of officers that are just overreacting who gets killed, that's a different story. And, you know, I think we can all agree that that's not something that should be happening. Patrick, do corresponding criminal cases that result in acquittals help or hurt your cases? Thinking about the recent case the DP cursor has. They certainly can help, you know, and they obviously can hurt. If you make it to trial and they say, you know, a unanimous jury acquitted you, you know, the obvious retort to that is, you know, the burden of proof is different, that they were acquitted because prosecution didn't satisfy by reasonable doubt, and, you know, different things are admitted into evidence, etc. What's more frustrating is when they will try and get into evidence that there was no disciplinary procedure even implemented by the police department, or that the person was acquitted, or pardon me, or that the grand jury no-billed the charges. Again, it's a different standard of proof. The really frustrating part about that is all grand jury proceedings are secret. So it's not like you can get the transcript from it. So a lot of the investigation you really have to do on your own. And it's, you know, when you do plaintiff's work, you're rarely paid by the hour. You know, it's contingency, and you really have to have your nose to the grindstone. The rewards and the payday can be enormous if you're successful, but you take a lot of lumps along the way. But, you know, at the end of the day, you know, some of you probably going to have offers from, you know, bigger firms or you know, big companies, whatever. They'll instantly offer you $200,000 a year, and you'll have the joy of sorting through documents and writing discovery responses and you know, other, you know, ghostwriting stuff for other people that take all the credit, while competing with your colleagues to try and impress the partner so that 7 years later they give you their work. You know, going down and tracking down data on someone with a severe criminal history, or police officers with a severe history of brutality, you don't get paid by the hour for that. You can't send a bill, you know. But again, it's you know, my wife at the time had she worked at Kelly Hart and Hallman in Fort Worth, and she was in the oil and gas section, and, you know, was doing her best to make the world safe for ExxonMobil. And you know, when work got light, they had to do a document review on a trademark case involving toothbrushes. And I was like, oh, well, you know, I tried to sue the government to get rid of a racist cop. So, you know, she made more money than I did, but I think I liked my job a whole lot better than she did. Anyway, that's just a personal vignette. Again, I'll share the screen just in case you didn't get the information, but I'd love to hear from you if you know, you have any questions about these cases, or you want some opportunity to work on them. I'd be grateful for your help.
Matt, before we dismiss, I do have a question.
Sure.
It's about the rise in body camera usage. Has the rise in body camera usage helped or convoluted the fact issue involved in the reasonable officer question, or the fact issue in what happened? If you can see it on video, does it help or hurt?
It has, as per usual, I'm going to say it depends. I mean, obviously, in the Darden case, it helped simply because there was no way to tell exactly what was going on. Also, where there's regulations that say that you have to use a body camera, and they, for some coincidental reason, turn it off right before killing someone, you know, that's a fact that helps. it can hurt in the sense that, and I want to be careful how I say this. If you do plaintiff's work, you'll find this, that a lot of times clients will come into your office that don't exactly tell you what really happened, okay? And there's a sort of a convoluted version of events that when you're able to get that body camera video, make you realize that a case that you may have thought was a, you're gonna, break the bank and really do something with, the body camera essentially proves that your client was lying. And the Supreme Court, in a case called Scott versus Harris a couple of years ago, it's typical. The Supreme Court only takes cases where the facts are so absurd that they should have been brought in the first place. But literally, like, the plaintiff swore in his summary judgment affidavit, I was taking a Sunday drive when all of a sudden the police snuck up on me and started firing shots at me, and I was obeying the law at all times, etc. And then the dashboard cam shows that he was like driving 100 miles an hour, in the opposite lanes of traffic, evading officers, driving through a field, whatever. And the Supreme Court said, if the video camera usage can affirmatively negate the affidavit testimony, the affidavit is not going to be sufficient to create a fact issue to get you by summary judgment. So, like I said, it's a gun that I'll pretend I'm from Texas for a minute. It kicks as hard as it shoots, and you got to be careful for that. Which, again, you can do a public records request and get that information before you file suit. And doing a diligent job of investigation on your own is really going to be the key to how your suit's going to proceed.
Okay, and I have one more. For a case to exist, to get past the common law qualified immunity restriction, as you just mentioned, the Fifth Circuit presents this scathing opinion about what happens in Kaufman County, but then turns around and says, well, we don't actually have a case like this, even though data suggests, yes, you do. There are plenty of cases like this. So what establishes the case? A ruling or
they said a ruling from your controlling jurisdiction, so now fortunately, now cops in Kaufman County know that they can't just fire bullets at unarmed children from 500 yards away. That wasn't taught in the police academy apparently, but now thanks to Windsor versus Kaufman County, we've established that that's the case. If my sarcasm isn't dripping here, it's the Zoom technology. But that's why I said earlier, the idea that these officers go home and read the Federal Reporter is too laughable to be said out loud by anybody that wears a robe. And yet that's been the law for 2 decades now. So that's ideally the thing. It has to be from your controlling jurisdiction, and it had to be the law at the time. So if cops had fired on an unarmed kid from 500 yards away in 2017, well, we didn't get that opinion from the Fifth Circuit until 2019. So they say, well, it wasn't clearly established at the time. So if you can see why there's a need for change in this area, I hope I hope this presentation has shown that, and I hope my sarcasm hasn't gotten you too jaded with the idea of working to pursue change. Sometimes the only way to you have to find a way to laugh because you'll cry your eyes out if you don't, and that's kind of what I do, and just try and illustrate in my briefs how bizarre some of these rulings are and how they really need to be overturned. And
the quick, I shouldn't say quick because it's obviously not a quick fix, but the end run around the judicial rule on this is actual legislative action. Yes?
Yes, exactly. So there's bills in Congress that would not only basically tracking the exact language of Harlow Fitzgerald and say it shall not be an action, it shall not be a defense in any case brought under this section that no objective officer would have done this and it's not earmarked by clearly established law. I mean, it just like completely overrules that case. There's other bills that are trying to introduce qualified immunity. I told you earlier, I'm trying to get ones that make these cases non-removable. The way I see it is we should shoot for the moon here because You know, there's no way the Democrats are going to get, 61 Senate votes, 61 Senate seats. So there's going to have to be some compromise. But qualified immunity is something that the police will definitely push back on, because they will paint this picture and be fair. I have several members in my family that are police officers. I don't hate cops. I mean, this is not an anti-cop thing. But they will say, it must be nice for you lawyers and you judges to have the ability to work from a nice office, and do whatever it is you do, talk about the law like from an ivory tower, but when you're executing a no-knock warrant in a dangerous neighborhood in Fort Worth and you don't know what's behind that door, the actions that we take have to be made in a split second. And sometimes they have unintended consequences. And that's a very good argument, but the actions that surgeons have to take often have to be made in a split second. That's not a unique defense for somebody who has a high stress job that requires you to think on your feet and act on your feet. And the long and short of it is it's just this racial debate that we're having right now, whether it's racial or the debate about the role of the police in American society, is going to escalate dramatically when this legislation comes to the floor, because you are either going to be seen as someone who poo-poos the idea of law enforcement and wants total anarchy, or someone who wants a fascist police state where they are essentially able to do whatever they want with impunity. And what we do as lawyers should be to avoid those extremes and to find a way to make intelligent arguments where people can meet in the middle and forge compromise. I always joke this, people will say, "Oh, why'd you go to law school?" "Oh, because I really like to argue." I'm like, well, that's not a reason to go to law school. That's just immaturity. You go to law school so you can solve problems, and just arguing with people is not, that doesn't get us anywhere. And so making cogent reasoned arguments for modifying this doctrine in a way that protects the lives of the people that protect us, but also gives some incentive to departments to provide additional training or additional resources, or for officers to maybe not be so overactive, let's say, in circumstances that don't warrant it. I mean, that's a result everybody wants. So let's find a way to get there, and it's only going to get there through reasoned discussion, and that's what we're taught to do. And that's why I hope some of you that choose to take these cases will consider pursuing, because we're not going to get anywhere with tweet storms and violent protests. We're going to get somewhere by coming to the table and making good arguments and letting smart people work this out. And if you're all at SMU, you fit that qualification. And my old intern, Hallie Dunlap, is on here, and I can see her, and I thought they need to give her a shout out, because she worked for me last summer and actually wrote, it wasn't a civil rights case, but she basically drafted an entire brief where we were the appellant, and we won, and the court's opinion basically tracked what she wrote. So she's a rock star already. Had to give that shout out.
Well, thank you all. If there are no more questions before we officially end the meeting, let's make sure that there are no questions.
Hi, I have.
Oh,
my
there
name,
you go.
I'm a 1L. I haven't taken. We don't have civil procedure for some reason during our first semester, so I was a little confused about like some of the procedural aspects. But I guess kind of just spanning out like from a broader perspective, I'm really enjoying criminal law, and we were talking today about like other forms of like getting redress for people that don't involve calling the police. And I guess I'm wondering, like, if you talk about your clients specifically, what are other ways in which you can get justice for them that's not like suing police officers after they've been harmed?
You can use a sack of doorknobs or a violent militia. Oh, no, I'm just kidding. Honestly, there is also, well, other than suing, I'm not really sure. That's just not my job. They bring me on to help with lawsuits. The idea that you can, there is I believe there's a police accountability board for the city of Dallas, for example, where you can lodge a formal complaint, you know, and have that officer investigated, and you know that might lead to his or her termination or suspension or something like that. That's not going to get you civil damages. I don't know of any like Texas or municipal based, like say arbitration proceedings, you know, where you could sit down and have a private proceeding and whatever. And frankly, I'm glad they don't. I want jury trials. I don't want, you know, secret star chamber courts and arbitrators making these rulings where nobody ever gets to find out what actually happened. But aside from complaining to the department and launching an investigation, or going to the district attorney's office and seeking an indictment, you know, your claims for damages are all you've got. And in Texas, our Tort Claims Act is a joke. I mean, it doesn't cover intentional torts, first of all. And if it has to involve, if you're going to sue for negligence, it has to involve the negligent use of tangible personal property, which courts have already held that guns and tasers and batons, that's not negligent use because they were intending to use them. And even if you could get by that hurdle, your damages are capped at like $250,000, which is ironic because they made that determination back in 1970, and they've never adjusted the $250,000 cap with the CPI. So back in 1970, that might have been a rather sizable award. You know, now it's 2 Cokes and a hot dog after you've paid your lawyer. So your real only remedy for obtaining at least monetary relief for your client. And that's just, you know, client's dead, that's one thing. Suppose your client's alive, you know, but they have a life care plan that's they're gonna be in traction for the next 20 years. I mean, who's paying that bill? You know, you need some source of redress, not just because, you know, you want a victory check. You know, it's because these people have outstanding medical bills, and will have major future ones as well, not to mention trauma, etc. So, Brendan, to answer your question, I really don't know of avenues outside of you know, legal recourse that's going to make much difference. And with regard to not having taken civil procedure yet, I can tell you that there are lawyers that have been practicing far longer than me that don't know federal civil procedure either. So don't stress. That's usually why they hire me. Like, you know federal court, Keita, you can handle that. But
what if like, instead of when someone sues the city, like the city pays, say like your client wins and the city pays, what if like the police department, like the money was just getting funneled from that? Do you think that they would feel the burden, or the, like, that they would change more?
I'd like to think that they would. You know, I honestly have no idea how the city of Dallas, for example, you know, funds its police budget, or, you know, if there's a suit against the city, does it come out of the general treasury, or is it, you know, I mean, it wouldn't make much sense to me to think that because one officer screwed up and somehow had you know, the city was willing to settle and enter into a settlement on his behalf, that they'd be like, oh, sorry, you know, I know you needed a bunch of guns replaced, but we're not going to do that now. We can't, hold on one second. We can't, you know, withdraw from the police budget to pay for one officer's mistake, you know. But, you know, another example though, and this is just, maybe some of you remember back in 2015, I think it was, there was a big motorcycle gathering at a Twin Peaks down in Waco, and a couple of cyclists got into a scuffle, and the police just arrested everybody on the scene. There was 199 people, and they took one arrest warrant with the name and address field blank, photocopied it, filled in all their names, and then accused them all of conspiracy to commit capital murder. Now, that's never happened before. Okay, so we don't have a case on point. So but we actually have that argument will be in the Fifth Circuit on October 5th if you're interested in seeing it. It'll be webcast. But the interesting issue there is, what happens if we win? Like, we would literally bankrupt the city of Waco, the county of McLennan. You know, I mean, like, without question. I mean, there were people that sat there in jail on $1 million bond for a month. You know, I mean, somebody was arrested was an American Airlines pilot. He lost his license. You know, people lost their children because it turns out ex-spouses, you know, can use the existence of a felony indictment to convince a judge that maybe they're not qualified to monitor their children. You know, I don't know. Being in jail for one night is something I don't want to think about, let alone a month on $1 million bond. You know, $1 million bond, it costs $100,000 to get just to get the bond. You know, and they were all released eventually, and no charges were brought. Now it's a little different because that's a false arrest claim, not an excessive force claim. But the point that you bring up is well taken. What happens? You know, I mean, the some of the actions that these officers have taken have caused astronomical amounts of damages, and that's another issue that's going to have to come to the table, because when the legislation comes up, of course there'll be people looking for damage caps. You know, think of all the city services that the city of Dallas provides, however inadequately. Sorry, I'm complaining about potholes, but I mean, we bankrupt the entire city to pay one person. I mean, obviously what the officer did was terrible, you know, but we got a city of, you know, what, 2 million people here. And all of these are pragmatic concerns that are going to have to be hammered out. And if we go too far one way, yeah, it might be a payday for plaintiff lawyers and for a couple of individuals lucky enough to have lawyers that can prosecute their suit. But we got to remember, we're paying for all of us here, and that's the important part. And that's why, you know, reasoned heads need to come together when we're trying to write these briefs and pass this legislation. Extremist positions aren't going to help anybody. It's just going to make the dispute between the cops and all of us even more pronounced, which, you know, if the cops feel more scared or they feel less liked, that's certainly not going to make them want to treat us with kid gloves. Let's put it that way. So anyway, I tend to yammer, so that was a long answer to your very short question, but that's my take on it.
All right. I'm going to plug a quick thing about concerning Brennan's question, and then we're going to end the meeting. I will point out that on that question of what happens with budgets and paying out some of these suits, is that some police budgets, some city police budgets, some police union contracts with their attached cities actually include the cost of potential excessive force lawsuits in the budget. So there's a line item that already contemplates paying out settlements involving claims of excessive force. Whether they're capped at an amount depends on the union contract or the city that they're associated with, but that's actually one of the biggest complaints that you hear in the rhetoric around defunding the police, is that they include in most of these larger city budgets, there's already a line item that contemplates settlements for excessive police, for excessive force, and that there aren't many taxpayers who are aware of those types of line items and budgets and things like that. But it depends on which city, and it depends on which the police department, and it depends on the police union contract. But we're right at 1:15, and I want to be respectful of those of you who have classes coming up in the next 10 minutes. So I want to thank you all for attending, for staying on the call. Thank you to Bree and to Patrick for asking for this particular subject to be addressed for one of our first Deason discussions. Thank you all for joining. I will ask Matt to provide a copy of his presentation, and when we post the video, I'll also see if he wouldn't mind if I send out his PowerPoint presentation. Thank you guys so much. Be sure he provided his email address. If you have more questions, I would suggest emailing, but as you can see, he's a busy lawyer with things happening. And if you guys have any questions of me, my email address is kenitra@smu.edu, or you can email the Deason Center at deasonjusticecenter@smu.edu. And I just put my email in the chat. So if any of you are interested in following up on the conversation, or you're looking for a particular type of conversation that you'd like to have in the Deason Discussion Series, just let me know. I make no promises, but I promise I will listen. So thank you all for joining us.
Thanks.
Yep.
Good to see you all. Take care and be safe.